Hello again and welcome to our video series on recent data protection decisions from the Court of Justice of the European Union. Today I'm joined by my colleague Shay Buckley from the Technology and Innovation Department at Arthur Cox to discuss the level of independence that must be afforded to data protection officers or DPOs within organisations.
Thanks, Aoife.
So today we'll be discussing case C453/21, which was referred to the court by a German court. Could you tell us a little bit about the background to the case?
Sure. The case concerned a DPO of a semiconductor company who was also chairman of the company's Works Council. The company in question considered that these activities were incompatible and dismissed the person from their role as DPO on the basis of a conflict of interest. Article 38.6 of the GDPR states that while a DPO may carry out other tasks and duties, these other tasks and duties cannot result in a conflict of interest.
And before we get to what the court decided, could you give us a quick reminder of the role of DPOs under the GDPR?
Of course, DPOs enjoy special protection under the GDPR and have to report to the highest levels of management of the organisation. DPOs can't be penalised or dismissed for exercising their DPO tasks and functions. Article 39 then sets out the main tasks that the DPO carries out and include informing and advising the controller and employees on data protection related matters, advising on DPIAs, monitoring compliance with the GDPR and applicable national legislation, and also liaising with supervisory authorities.
Okay, and so what did the court have to say then about conflicts of interest in the case?
The court held that using the everyday meaning of the phrase conflict of interest, the DPO cannot be entrusted with performing tasks and functions which impair the execution of their functions as DPO. In particular, the court noted that the DPO cannot be entrusted with tasks and duties which would result in them determining the objectives and methods of processing of the personal data by the controller.
And did the court provide any examples of what a conflict of interest might be?
Unfortunately not. The court did note that the assessment of whether or not there is a conflict of interest has to be carried out on a case-by-case basis by the national court, and this assessment must involve consideration of all of the relevant circumstances, including the organisational structure of the entity and also a consideration of any of the policies that are in place.
So in 2023, the European Data Protection Board conducted a coordinated enforcement action in respect of DPOs. Could you tell us a little bit about that, please?
Sure. The EDPB found that despite some concerns and challenges faced by DPOs, such as a lack of independence, challenges in reporting to the highest levels of management, and insufficient expert knowledge, the results of the coordinated action were quite encouraging. The EDPB found that the majority of DPOs involved in the action had the sufficient level of knowledge and skill, weren't receiving instructions on how to exercise their duties, and also had clearly defined tasks as set out by the controller or the processor.
And did the report that the EDPB produced consider conflicts of interest?
Yeah, so the report referred to the case that we're discussing today and noted that the Court of Justice has recently clarified the term conflict of interest. Despite this, the EDPB did note that the results of the action show that there is some conflicts of interest or possible risks of conflicts of interest arising. In this regard, the EDPB noted that their own guidance, the EDPB's guidance on DPOs, should be developed out further and in particular should take account of any of the new tasks that DPOs might be asked to take on under new legislation, EU legislation in the digital space.
And did the EDPB make any other recommendations?
The EDPB noted that supervisory authorities could take more actions to verify that controllers have appropriate safeguards in place to avoid conflicts of interest. They also noted that there could be more awareness-raising activities and enforcement actions by supervisory authorities and controllers as appropriate on the independence of the DPO. The EDPB also noted that DPOs should be able to collect evidence of any interference with their independence in their role.
We can see then that 6 years on, or almost 6 years on from the coming into force of the GDPR, the parameters of a key role created under it are still being figured out, and we can see there that there's been court focus and also regulatory focus on it. So thanks very much for your time today, Shay, and thank you all very much for watching.